Welcome to the next episode of the Isn't That Rich podcast. In September of 2023, Farmer State Bank hosted a half-day seminar called The Legacy Sessions, featuring 4 guest speakers who are all experts in their industry and helping clients build a lasting legacy. We recognize how beneficial the information they shared was, and we wanted to give our listeners the opportunity to hear what they had to say. Today, we're happy to share with you part 2 of the Legacy Sessions.
In the journey of life, we all strive to build a legacy, accumulate assets, and provide for our families and future generations. But the path to preserving and distributing our wealth can be intricate and filled with legal complexities. This is where the expertise of an estate planning attorney become invaluable.
Our next guest today is not merely an attorney, but a trusted guide, a guardian of your financial well-being, and a protector of your family's future. He is the go-to expert in navigating the labyrinth of wills, trusts, probate, tax optimization, and all facets of estate planning. It is my distinct honor to introduce you to our next speaker, Attorney Evan Taylor.
Thank you very much. Thank you for that introduction. I've been an attorney for many years now. I'm not even going to state the number at this point. But in addition to doing estate planning, I have significant experience in real estate law and business law as well. And I think this makes me well-rounded as an estate planning attorney because, as you probably heard from Adam when he was speaking, there's often business issues in estate planning. Those can go hand in hand, and there's real estate issues that come up. And just based on experience, those are issues that aren't typically either addressed at all or appropriately addressed to where your business, your real estate, and your estate plan are all working together. I'm going to kind of break this presentation into 2 main parts. I'm going to spend the first part of the presentation talking about the tools that I use in estate planning or that attorneys use in estate planning, give you more details on what they are, how they work, and then once I go through the estate planning tools, then I'm going to talk about the goals. Why do we use these tools? What are we trying to accomplish with estate planning? Why is it so important? To start out, I want to talk about just estate planning in general, and estate planning is all about protecting your legacy. Protecting it, preserving it from various contingencies. It's simply the process of preparing for the seamless transfer and protection of your wealth in the event of your incapacity or death. I'm going to be giving you a lot of information in a short amount of time, and it may be a lot to take in, so I would encourage you. I offer a free consultation, so if you want to talk more about this, talk about your individual situation, I can really then tailor this information to you. One thing, if you retain nothing else out of this presentation, one thing I really want to hit on is what's on the screen right now. The legal documents that are prepared as a part of your estate plan should always work hand in hand with your financial plan. That is absolutely critical in estate planning. A lot of people think of estate planning as the documents, and any attorney can draft you the documents. You can get the documents off the internet, off Google. There's legal websites that'll get you a will, get you a trust, but it's absolutely critical that those documents work with your estate plan. There has to be that additional step to make sure what documents we have in place go hand in hand with your assets, how they're held, whether it be business, real estate, financial accounts. Everything has to work together. I just met with someone earlier this week who had a trust plan, beautiful binder full of documents done, had went to another attorney, had it amended. So 2 attorneys had worked on this plan. We started talking through what she had in the documents, her estate, her assets essentially, what are her goals, and it turned out what she had in place was not at all what she wanted and what she thought was going to happen. So now we're having to get that corrected for her. So if you have no estate planning, I highly recommend getting some done. Even if you have estate planning, it's important to have that reviewed routinely as well, just to make sure it is doing what it's supposed to do. It's kind of a general list of the different estate planning tools that I'm going to talk through, but I will talk through these in more detail, kind of slide by slide here. I want to start out with the last will and testament because I think this is the document that most people think of when you think of estate planning. It's the first thing that comes to mind. You've probably seen on TV or movies or what have you, the scene with the attorney sitting at the desk, everyone, the family's all around, the attorney's reading the will, someone's crying because they got left out or something like that. So a lot of people are very familiar with the last will and testament. And it is a very important document. I consider it the foundational document of any estate plan. Everyone at a base level should have a will in place. And there's a lot of benefits to a will, but there's a lot of drawbacks to a will as well. And that's because a will is just a declaration. You're just stating what you want. So it's not a separate entity like a business or a trust. It's not an agreement, a legal contract. It's simply you stating on paper, this is what I want when I pass away. Because it's just a declaration, it in and of itself doesn't do anything with the titling of your assets, with marshaling those assets, or anything of that nature. So it has some drawbacks. In and of itself, it doesn't avoid probate, so that court-administered process of handling your estate. It doesn't protect you from any tax issues. It doesn't protect you from any long-term care costs, so like nursing home expenses, things like that. So we're often having to couple the will with other documents, other planning to make sure everything's taken care of properly. Will is still very important though, because you can, state how you want your estate assets to be divided. You can appoint your executor, so that's the person that's going to handle your estate, pay your last bills, make sure your wishes are upheld, deal with the funeral home and things of that nature. Also, if you have minor children or if you have adult dependent children or other dependents, in your will you can state who you would want to have guardianship over those individuals, or sometimes more importantly, who you do not want to have guardianship over those individuals as well. So a will is a very important baseline document. For some people it is enough, but for a lot of people we have to do some additional planning beyond just the will. Some of that additional planning usually consists of a trust. And so I want to talk about trust just in general, and then I'm going to talk about two main types of trusts, revocable trusts and irrevocable trusts. But just to let you know what a trust is, because I'm sure you've heard that term a lot, but may not really know what it is or how it works. A trust is simply a three-party fiduciary arrangement. You have your grantor who's creating the trust, you have your trustee who's managing the trust, and you have the beneficiary who is obviously the beneficiary of the trust. Depending on the type of trust, those three parties can all be the same person. So you could create the trust, be the grantor, you could be the trustee and managing the trust, so managing your own trust, and you could be the beneficiary for your life as well, so have all the control over the trust and be able to do whatever you want with it. Trusts are often used for those additional considerations, concerns, and goals in estate planning. So avoiding that court-administered probate process, protecting from long-term care costs, minimizing or reducing or completely eliminating estate taxes as well. Start off with the revocable trust, and as the name implies, it's a trust that is revocable. Here, when I go back to that three-party arrangement, in a revocable trust, you can be that grantor, trustee, and beneficiary. So this is a simple trust that you can amend, change at any time, completely revoke, and it's a pass-through entity, meaning it's not hard to maintain. There's no tax ID number, no tax returns required, anything like that. So it's often a popular choice because of its simplicity. But even though it's a simple trust, we can still use it for a few main reasons that I use revocable trusts. One is to avoid probate. So we transfer assets into the trust so they're not part of your estate and subject to probate. And I'll talk more about the details on probate later in this presentation. The other thing that trusts are often used for is to give you greater leeway over the distribution of your estates. And I'll talk through this more as well. But should we just be giving your estate outright to the beneficiaries, or are there various contingencies that need to be addressed? Does the money need to be held in trust? And revocable trusts give us this leeway as well. The drawback to the revocable trust is because you maintain that control, because you're each party in that three-party fiduciary arrangement, it's still considered your asset by the government when it comes to tax purposes and long-term care purposes. So while the revocable trust gives you great leeway with distributions, helps you avoid probate, it does nothing to help with long-term care nursing home expenses. It does nothing to help with any tax issues you may have, and that is a common misconception that I see is people think they have a trust of any type, their assets are protected in that manner. The irrevocable trust is what we then lean to help with tax issues, to help with long-term care costs, so applying, qualifying for Medicaid, things like that. The irrevocable trust, when you again go back to that three-party arrangement, here you cannot be grantor and trustee. Someone else has to be in control of your trust. That in and of itself sometimes makes it difficult or impossible for somebody to want to enter into an irrevocable trust because they may not have someone in their life they want managing that asset. But the great thing about getting that asset into that trust and out of your control is the assets you put in can then reduce out of your taxable estate, or they can be protected from spin downs like Medicaid spin downs, long-term care costs. Some other documents, some of these you'll see as part of any estate plan. Powers of attorney. So here you're still alive, but you can no longer make decisions for yourself. I draft these as part of any estate plan that I do because they're always necessary just in case something happens to you and you cannot make your own decisions. Two main types you'll see are the power of attorney for healthcare, so who's making your healthcare decisions for you, and then the power of attorney for property. It's also often called the financial power of attorney, so who's going to make financial decisions for you while you're alive, but you can't make them for yourself. Once you pass away, those documents then revoke, and then we're looking to your will, trust, or whatever documents you have in place as to who is in charge at death. Payable on death designations, transfer on death designations, those are always important to consider when you're doing your estate plan. How do you have things designated as far as your financial accounts, or do you have them designated at all? Do we need to update the designations? Do we need to make a trust the beneficiary of your accounts? So it's always important to consider those designations. Another document you'll often see is a transfer on death instrument. This is a document that looks a lot like a deed. You record it like a deed, but it doesn't do anything with your real estate until you pass away, and then at that time it passes it to the beneficiaries that you've listed in that transfer on death instrument. Another document that I always give people the option to sign is a living will. So unlike the last will and testament, this is the living will. It's also a declaration, but it's a declaration of your end-of-life desire. So if you're in an irreversible, incurable condition, essentially where a doctor deems this person is not coming back, this allows you to be made comfortable, but also allows you to die naturally, so just not artificially prolonged on machines indefinitely. This document really came to the forefront in people's minds a couple of decades ago. I don't know if you remember it. There was the Terry Schiavo case. I believe it came out of Florida, where a young lady was, I think this was arguable, but was in a persistent kind of vegetative state. And if I'm remembering the facts right, her husband wanted to take her off of that life support. Her parents did not. It became a huge legal battle. It became national news. If she had had a living will, that would have solved that issue and there would not have been any debate or argument. Shifting from the tools to the goals, so I've kind of given you an overview of what kind of documents we use. Now I want to talk about the things that I kind of talk about in any initial consultation that I have with clients. The first one that I like to hit on, because I think it's what brings most people into my office, is distributions. Just making sure your assets are going to distribute to who you want them to go to, or to specifically state who you do not want your assets to go to. This is very important for your legacy protection. You want to make sure it goes to the right people, and you want to make sure it goes to people that you'll know will use it how you want them to use it. At a surface level, distribution seems very simple, and most people have thought about it on the surface level. Let's just take kind of a nuclear type family, husband, wife, 3 children, joint biological children, so no subsequent marriages, anything like that. They've thought it through. They want everything to go to the kids, 1/3, 1/3, 1/3. Let's be fair. That's the easy part. That's the surface level part. But we need to consider and think beyond just the 1/3 distributions. Are there any contingencies? Is there anything we need to think about as far as protecting those 1/3 shares? Are any of the children minors? We don't want a 12-year-old to get 1/3 of your estate. So when do we want them to get it? Is it at certain ages, a certain age? We can provide for all that through a revocable trust plan. Are any of the beneficiaries disabled? So any of those 3 children disabled? In all of my estate plans, I have a supplemental needs trust. This trust allows us to shift their share, in this case that 1/3 share, into that trust. That way they can keep receiving any benefits that they have been receiving. They don't get kicked off of any benefits, and they don't have to pay back the state for any benefits. So they can keep what they've been receiving, and they can get their 1/3 share. So again, all about legacy protection. Are any of those 3 kids spendthrifts, or are they in financial trouble to where we don't want to just give them a lump sum distribution? We can again protect their share for them. Going even beyond that, what about contingencies if something's happened to one of those 3 kids? What if they die in a common accident or have predeceased you? Do they have children? Do we want that 1/3 share to then pass down to those children? Or do we want it to go on over to the 2 remaining siblings, the children of the parents in this situation? So distributions are very important. It's to think through all the different scenarios, because the last thing you want is to just say you want it to go 1/3 to each of these kids, but then there be something happen that we've not planned for, and the whole plan gets messed up. We're in court trying to figure it out. We need to think through all the contingencies. Going even beyond that, we always like to put a remote contingent distribution in a will or trust. So that's kind of like a disaster clause. So what if something's happened to the parents? All 3 kids are gone. So all 3 kids are gone in this situation. Maybe they were all in a car wreck. They have no kids. What do we do then? We want to make sure we're always providing for some ultimate distribution so we know what to do with your estate if something happens. So distributions, you really have to dive into detail in that initial consultation to make sure we're structuring everything properly in your estate plan. Probate avoidance. So this is another goal. I don't mean to talk about probate necessarily like it's a bad word. Sometimes it may be necessary depending on the estate, but it's also typically very easy to avoid in estate planning. And I've mentioned probate several times in this presentation, but I've not really discussed what it is or why we need to avoid it. So with probate, anytime someone passes away, their estate has to be settled, meaning we got to collect the assets, we got to pay the debts, then distribute the assets. That settlement of the estate can be inside the court system or outside of the court system. So when I talk about probate, all I'm talking about is that inside the court settlement of an estate. So when we have to go to court to effectuate your goals. So with probate, it's not the end of the world, but it is an expensive and lengthy process. In Illinois, you have to hire an attorney to handle a probate. You have to file a petition and other documents with the court to get that estate opened, to get your executor appointed. You have to do inventories, you have to do accountings. You have to publish in the paper, kind of a strange rule, once a week for 3 consecutive weeks. You've maybe seen some of these notices in the paper before. And that starts a 6-month claim period where anyone that claims you owed them money or had some kind of debt to them can file a claim within that estate. So it kind of gives people an avenue to fight. So it's a lengthy process. It can become a complex and contested process. And what most people really don't like about probate is it's a very public process. All your business kind of gets laid on the table and it's there in a court file in public record. So we can avoid those expenses, that time, that money, that public ordeal through your estate planning. So what triggers this probate process? Why do some estates have to go through court and some don't? And it's really all about your assets and how they're held. The two kind of main triggers that we see as far as probate, one is if you pass away with real estate just in your name, that's going to trigger a probate. The other is if you have cumulatively assets of $100,000 or more just in your name with no designated beneficiary, your estate will have to be probated. So now that we know what causes probate, we can now use those tools that we talked about earlier to avoid it. So if having that real estate in your name when you pass away triggers probate, we put the real estate into a trust. It's not in your name, and that trust can be used as a vehicle to bypass that probate process. If having designated beneficiaries on an account keeps it from being a probate asset, then we make sure you have designated beneficiaries on that account, whether it be the heirs you want or whether it be a trust or some other vehicle, just to make sure nothing is in that estate that's going through that probate process. One of the more common misconceptions that I see is people think that probate estates are only when people didn't do any planning. So a lot of times a family will come to me with a will after someone passes away and kind of just say, well, now how do we get this money? How do we distribute these assets? And we start going through them, and they have to go through probate even though they had this will. So it's all about the assets, how they're held, and that's why it is so important, not just the documents, but the funding as well, making sure we go through your assets and we're taking care of everything properly. Anytime I do an estate plan, along with it I do an asset spreadsheet where we line by line list out all your assets, how it's held, does it have a beneficiary, and a to-do list in that last column, whether that be nothing. Maybe it's exactly how it needs to be, but you will know everything we need to do to make sure probate's going to be avoided, and that's just more money in your legacy to pass on. Long-term care costs. So this is another important consideration. It's something that a lot of people do worry about, because if you want to see your legacy get spent down fast, that can happen in a nursing home. So when I talk about long-term care costs, I'm talking about a long-term stay, typically in a nursing home, but it could be assisted living or even in-home care, where Medicare has run out. So now you're looking at Medicaid, which is a completely needs-based program. You must qualify, and the only way you can qualify is to, for the most part, spend down all of your assets. So there's a few ways to alleviate this problem, because you never want to just be in a nursing home just spending with no end in sight. And so one thing is long-term care insurance. Long-term care insurance is great, but it's getting much more difficult to get, and the terms of the policies are getting way less favorable. So a long-term care policy simply pays for your long-term care. It will pay the nursing home bills for you, but the amounts per month have been going down, so there's been shortfalls, and the time length. Used to, you would see a lot of unlimited plans, and I still see those occasionally if someone's had that plan for many years, but you rarely see that anymore. It's typically 3 years or so as far as the term of the plan. It can also be very hard to qualify for long-term care insurance, but if you are concerned about nursing home costs, it's something worth looking into. But assuming you don't have that, there are things we can do in your estate planning as well. We can use the estate planning tools that we discussed before to help minimize or avoid that Medicaid spend down, your assets being subject to a Medicaid spend down. And thinking back earlier in the presentation, the tool we need to use is an irrevocable trust. If you remember, that's the trust that gets the asset out of your name and out of your control. Once we get that out of your name and control, it's not an available asset that can be spent down before you qualify for Medicaid. It does, however, for full protection, have to be out of your name 5 years before you apply, because when you apply for Medicaid, they don't want to just know what do you have today. They want to know what you've done the past 5 years to prevent people from just giving away all their assets and then applying. So this is a very complex area of estate planning. If you do have those long-term care concerns, maybe a history of Alzheimer's or dementia in your family, it's something worth really talking through to make sure we're protecting things for you. Tax minimization and avoidance. When I was reviewing this presentation, going back over this PowerPoint, I realized my numbers are wrong on this screen, but they're close enough for the purposes of this presentation. The thresholds at the federal level and the gift tax exclusion are both higher now, but they're still very high for historic purposes. So with estate taxes and taxes in general, when it comes to estate planning, you know, I think I'm probably going to butcher this saying, but the two things that are certain in life are death and taxes. If you're not careful, you're going to get hit with both of them at once because there is a death tax, for lack of a better term. There's really two ways you typically see governments tax estates. There's the estate tax, which looks at the value of your estate and then taxes it, then we distribute it. There's also an inheritance tax, so we distribute the estate, then we tax the person getting it. It's just two different ways to do the same thing. Some states have no tax, some states have an estate tax, some have an inheritance tax, some unfortunately have both. The federal government, though, and Illinois both have an estate tax, so they tax your estate, then we distribute it. We're living in kind of a golden age when it comes to the estate tax thresholds, and so your estate will not get taxed unless it exceeds a certain value, and then it gets taxed at a graduated rate above that value. There's been times in history where that value was very low, and so a lot of people were doing different types of trust planning, using irrevocable trusts to get assets out of their estate so it wouldn't be part of that taxable value when they passed away. Right now, they're relatively high, both at the state and federal level. Illinois is at $4 million, and it's been there for quite a long time, and it's not raised in a long time. The federal level has gone way up, and it continues to go up, and I believe it says 11.2 and 22.4. I think it's somewhere around 12.9 and whatever double that would be, 20, 25, 26 million for a married couple. So if you're under those amounts, you will not be taxed. Oftentimes people think they're not going to fall, especially in that Illinois range, that $4 million. But when you really start adding their assets up, particularly if they're business owners, they have key man life insurance policies, things like that, the amount can add up quick. And so there's ways we can transfer assets to trust to get that out of your taxable estate as well. Just to kind of end on some special kind of considerations, this probably isn't the best title for this slide, high net worth. Really, you have special considerations anytime you have a multitude of assets, be that real estate holdings, a business, maybe it's rental property, so you have real estate holdings and a business. It's important to talk through those. And again, like making it go hand in hand with your estate plan, you need to make sure your estate plan works with your business plan. You don't want your trust to say one thing, and I'm sure Adam hit on buy-sell agreements and things like that in his presentation. You don't want those to contradict, because then you're going to get a fight and you're going to have a legal battle and it's going to get messy. So we always have to make sure everything is kind of meshing within your assets and your estate plan, your business plan, your real estate. We also want to make sure you're kind of compartmentalizing those assets. So if you own a lot of real estate, do you really want all that in your individual name? Let's say you have many rental properties. Somebody gets injured on one. Do you really want everything potentially subject to that? So why don't we put some rental properties in an LLC or maybe multiple LLCs, so we're creating barriers, protecting your assets, and again, protecting your legacy as well. Blended families. I always like to at least stop and talk about this just for a second. When I was doing distributions earlier and talking through distributions, I kind of gave that just kind of more nuclear, simple family situation, but that's really not the reality for most people. Most people don't have that simple of a family situation. I myself kind of came from like a quasi Brady Bunch scenario where it was me, my two older sisters, and then I had three stepsisters. as well. So when you have those kind of blended family situations, estate planning is even more important, and it's more important to really go to an attorney that understands the nuances of estate planning. If you're sitting there and you have a blended family, so multiple marriages, stepkids, half kids, whatever the case may be, you need to get planning immediately. Even if you have planning, you need to review it because it may not be enough. Kind of going back to distributions, before we were kind of talking about everything going to the 3 kids and the different contingencies there. But when you have a blended family, you have to kind of go up a level and talk about, well, what if one of the spouses dies? Is everything just going to the other spouse? Or is some going to the other spouse, some going to the deceased spouse kids? How do we want that to look? Do we need to divide assets within a trust so that each spouse has a trust? So a lot of considerations there, again, just to avoid fighting later and avoid issues, avoid family drama. Just in my opinion, I'm sure Adam would share this as well, we deal with a lot of contested estates as well, and that's something I wouldn't wish on any family. And the vast majority of the time, it's a blended family situation where there either wasn't planning or there wasn't enough planning. One of the nastier pieces of litigation I've ever been involved in was just that. A lady with pretty significant assets, she'd created a trust through one attorney. Over time, she'd amended that trust several times, utilizing some other attorneys. She passes away though, the documents look great, but again, I know I've said this probably too many times, that funding was not done. The analysis of the assets were not done. So we had documents and assets contradicting one another, and it became an immediate fight and a drawn out fight, and those become very costly, and you don't want your legacy going to attorney fees. Kind of as a final matter, again, I'm an attorney at Lawler Brown Law Firm, mainly handling estate planning, but we do all types of law at Lawler Brown Law Firm. We do business law, real estate law, civil litigation. I hope you don't need criminal defense, but we do criminal defense as well. So please, if you need us, please call us, and please feel free to schedule a consultation with me. And that is all I have. Thank you all very much.
What an amazing presentation from Evan Taylor. It was truly eye-opening on the topic of estate planning, something that really applies to all of us. We're so excited for next week's episode with John Forbes on the Legacy Sessions Part 3, so stay tuned and listen in.
So Jill, where do we go from here?
Be sure to check out our show notes for this episode, and also be sure to follow us on social media and subscribe to our newsletter. We'll see you next week.
See you next week.